Finality start. But in the instant case, the charges were initially framed against the accused for the offences under sections 498A, 302, 304B, 114 read with section 34 of the IPC besides section 3 and 4 of the DP Act. There is no dispute relating to the well-established principles of law that when major offense has been lugged against the accused and the charges were framed, it is the domain vested with the trial court to arrive at a conclusion which is based upon the evidence facilitated by the prosecution and also marking of documents with regard to providing the charges leveled against the accused. But it is only an appreciation of evidence and also appreciation of the material documents which were got marked on the part of the prosecution. However, in the instant case, the petitioner accused being grave men of the charges leveled against them, they have to face trial for the offences for which charges have already been framed by the trial court and then proceed with the case for recording the 313 statements of the accused and set down for judgment. But in the meanwhile, the prosecution has made use of the provisions of section 216(1) CRPC merely because any court may alter or add any charge before the judgment is pronounced. The word may is implied that the trial court may to exercise the power in the stricto sensu, keeping in view the object and scope of section 216(1) of the CRPC for altering or adding any charge where the accused requires to face trial. But admittedly, the deceased Latha laid died in her matrimonial home. It is noted here that the entire case has been set down for trial and also recording the incriminating statements appearing against the accused. Subsequently, to hear the arguments on the part of the prosecution and also on the part of the defense, then it would be set down for pronouncement of the judgment. The same indicates in this petition whereby the stay has been granted relating to challenging the impugned order passed by the trial court. Therefore, it is said that when there are major offences lugged against the accused and charges are framed and also the prosecution has set down for trial and close the prosecution case, then the case has been set down for pronouncement of the judgment in SC number 73 oblique 2012. In the meanwhile, merely because the law provided the trial court cannot alter or add any charge at any time before the judgment is pronounced. At this juncture, making an application by the prosecution for invoking other offences to frame a charge and proceed with the case for investigation will only come in the way of the trial of the prosecution. But in the instant case, the charges are framed on 9/6/2015 and the accused have been facing trial even for the allegation made that they had given physical as well as mental harassment of the deceased Latha and also for offences under section 302 of the IPC merely because she has died within 7 years from the date of her marriage. Offences under section 3 and 4 of the DP Act 1961 have been invoked, and so also other offences as reflected in the charges framed by the trial court against the accused. Therefore, it is said that when offence once the case is set down for rendering judgment based upon the evidence facilitated by the prosecution and also marking of documents secured by the IO during the course of investigation, it is a domain wasted with the trial court to appreciate the evidence and render a judgment in accordance with law. Therefore, at this stage, prosecution making an application under section 216 read with section 221 of the CRPC for invoking and framing additional charge under section 306 of the IPC does not arise. Consequently, the contention taken by the learned counsel for the petitioners being justified intervention is warranted. If not, certainly there shall be miscarriage of justice and abuse of process of law, wherein grave men of the accused would suffer in case of allowing the application filed under section 216 CRPC at this stage of the proceedings. In view of the aforesaid reasons, I am of the considered opinion that this petition deserves to be allowed. Accordingly, I proceed to pass the following. The petitioner filed by the petitioners accused under section 482 CRPC is hereby allowed. Consequently, the order passed by the court of the principal district and session judge Devanagari in SC number 73 2012 dated 26/7/2016 is set aside. Consequence upon setting aside the impugned order, the application filed by the prosecution under section 216 read with section 221 CRPC stands rejected. Stop.